We're getting now to a very, very basic, very fundamental issue, and then it goes back a long time, almost to the very beginning of our history as a constitutional republic. In Marbury versus Madison in 1803, the court basically established itself as the ultimate arbiter of the Constitution. Thomas Jefferson strenuously objected to this. He said this would establish the tyranny of the judiciary because they would be the ones who could decide what was constitutional and what was not, regardless of the legislature, regardless of the executive departments. I'm wondering, what do you think of this case? Should the judiciary have this kind of power? Are they the ultimate arbiter of the Constitution? And was Thomas Jefferson right?
Well, I think that Marbury versus Madison didn't do as much as the courts claim it actually does today. I think that John Jay, the justice of Marbury versus Madison, would be outraged at this point of what we have actually used Marbury versus Madison to mean. But that being said, I believe that Jefferson was absolutely correct. And not just simply because of Marbury versus Madison, but because Jefferson knew history. And history dictates, see, I teach a history lesson, the history of our Constitution. And what I do is I show the 700 years that it took to write the Constitution. There are 5 documents that were used throughout those 700 years to create every single aspect of our Declaration of Independence, our Constitution, and our Bill of Rights. These 5 documents were the written Liberty Charters, the written Constitution of the British Kingdom. And throughout tracing that history and this battle for liberty that established each new advancement for the people and their lesser government and securing more liberty of the people, each time they complained that one of the first mechanisms of tyrannical government was the courts getting out of control. And so Jefferson had a lot to say about our courts being out of control. He said, the germ of destruction of our nation is in the judiciary, an irresponsible body, working by day and by night, gaining a little today and a little tomorrow, advancing its noiseless step like a thief over the field of jurisdiction, until all shall render powerless the checks of one branch over the other, and shall become as venal and oppressive as the government from which we separated. Because you see, governments become corrupted through their court systems. That's the way it always works. And what's happened in America is that we have, even through our own language, you corrected yourself early on. We say courts issued a ruling, right? Right. Courts don't issue rulings. Kings issue rulings. Courts issue opinions. And by Article 3 of the Constitution, and by Article 6, Clause 2 of the Constitution, if the court's opinions do not comply with the Constitution, they're no more binding on you than your next door neighbor's opinions. But we have this elevated opinion of the courts so that they issue rulings. How many times have you heard that heard somebody say, well, Roe v. Wade is the law of the land? Have you heard people say that?
Yeah.
It's not true. There is no federal law on abortion. And as a matter of fact, if the federal government tried to pass a law regarding abortion, it would be an unconstitutional law, because determining life is not a power that's been delegated to the federal government. But we think that courts make law with their opinions, or their rulings, as we call them. But if a court makes a law, that's a per se violation of the Constitution and separation of powers, which means it automatically is null and void. It's the very thing that Jefferson was saying. We have created, through our deliberate teaching in our government schools, through our deliberate teaching in our law schools, that we have now an oligarchy of 9 kings and queens that rule over America through a situation of judicial supremacy. I can't tell you how many legislators on the state and national level I've confronted about this. And they all say, well, you know, when the Supreme Court says that makes it the law of the land, and that the federal court's opinions are superior to the state's laws and the state's constitution, they can't support that by the Constitution. They can't do it. And so what they end up doing is using Marbury versus Madison and the precedent that is built upon Marbury Madison, snowballing these courts into judicial supremacy and oligarchy. You see, it's just a matter of, well, the court said, so now the court can do. It's circular logic. But we have failed to teach the truth about the true limitation of the federal government. Do you know that James Madison wrote in 1800 that the states were superior to the federal judiciary?
Yeah.
He said, if the judiciary is superior to the states, then the judiciary can overwrite the Constitution, and the states are nothing but subjects.